Before we begin, remember that this video is for educational purposes only and isn't legal advice. Always consult a qualified attorney for your specific situation. Most people make legal mistakes simply because no one explained the basics. Let's fix that. Before you put pen to paper, you need to know that most people lose money not on the price, but in the fine print. We're going to break down the 5 critical areas that can make or break your deal, from hidden costs to exit strategies, so you can sign with total confidence. Alright, let's start with the real-world problem. This is the part that helps you understand what is actually going on before you spend money. Many people sign contracts with a brand name rather than a legal entity, which can make it impossible to sue if things go wrong. You want to ensure the contract lists the full legal name of the LLC or corporation as registered with the Secretary of State. If the name is just a DBA or nickname, you might be dealing with an individual who has no assets. Always double-check that the person signing actually has the authority to bind that company. A vague scope of work is the fastest way to end up in a dispute over what was actually promised. If a contract says marketing services without listing hours, platforms, or specific goals, you're at the mercy of the provider's interpretation. Ensure every deliverable is defined with concrete nouns and measurable outcomes. If it isn't written down in the scope section, assume it isn't happening. Knowing what isn't included is often more important than knowing what is. Many contractors leave out things like permit fees, travel costs, or material surcharges, then surprise you with a bill later. A high-quality contract will have a not included or exclusions section to manage expectations. If you don't see one, ask for a list of common additional costs that usually pop up. Time is money, yet many contracts fail to set a hard deadline for completion. Without a timeline, a provider can push your project to the back burner indefinitely without being in breach. Look for specific dates or milestones that trigger certain phases of the work. This keeps the project moving and gives you a clear point to walk away if they fall too far behind. Now let's talk about the money. Most people focus on the total price, but the how and when of payment can be even more potentially concerning. Never pay 100% up front. It removes any incentive for the provider to finish the job quickly or correctly. A standard schedule involves a small deposit, progress payments, and a final retentions payment held until you're satisfied. This structure protects your cash flow and ensures the work meets your standards before the final check is cut. If a provider demands total payment before starting, that's a major red flag. Check the fine print for aggressive late fees or sky-high interest rates on unpaid balances. Some contracts bake in 2% monthly interest, which can compound into a massive debt if a payment is delayed by a bank error. You should negotiate a grace period, usually 5 to 10 days, before any penalties kick in. This protects you from technical glitches that shouldn't cost you hundreds of dollars. Software and service contracts often include evergreen clauses that renew the contract automatically unless you cancel in a very specific window. If you miss that window, you might be locked in for another year of a service you no longer want. Always mark your calendar for the notice dates, which is usually 30 to 90 days before the contract ends. Better yet, try to strike the auto-renewal clause entirely during negotiations. Quick reminder, this is educational content only, not legal advice. Laws vary by jurisdiction, so always check with a local attorney. Every good relationship needs a clear way to end. If things aren't working out, you need a safe way to leave without getting sued. This is the no-fault divorce of contracts, allowing you to cancel for any reason just by giving notice. Without this clause, you're stuck paying for the full term, even if your business needs change or you simply don't like the service. Usually, this requires a 30-day notice period. It provides the ultimate flexibility, though some providers may charge a small, may negatively impact fees to include it. If the other party stops showing up or does a terrible job, you need the right to fire them immediately. This clause defines material breaches, like missing 3 deadlines in a row, that allow you to end the deal without penalty. Make sure the contract defines what a may help support period is, which is the amount of time they have to fix the mistake before you can walk away. If they can't fix it in 10 days, you should be free to go. The contract doesn't truly end when the work stops. You need to know what happens to your data and intellectual property. Ensure the contract requires the other party to return your files and delete sensitive info within a set time frame. You also want to verify that you own the work products once you've paid for it. Don't leave your assets in someone else's hands just because the service ended. This is the shield part of the contract. It's about making sure you don't lose your house or your business over a single mistake. Indemnification is a fancy word for who pays if someone gets sued. If a contractor does something lesser known while working for you, you want them to pay for your legal fees, not the other way around. Be very careful with mutual indemnification, as it might force you to pay for their mistakes. Always read this section twice. It's often where the most significant legal risk is hidden. This clause caps the total amount one party can sue the other for, usually at the total price of the contract. Without this, a small $1,000 mistake could lead to a $100,000 lawsuit that wipes out your business. You want to ensure there's a reasonable ceiling on damages. However, make sure things like gross negligence or fraud are excluded from this cap so you're protected from truly bad actors. A contract is only as good as the money behind it. If a contractor causes a fire but has no money and no insurance, your contract is just a worthless piece of paper. Always require the other party to carry general liability and workers' comp insurance. Ask for a certificate of insurance, COI, before they start work to prove they're actually covered. It's a simple check that prevents a catastrophic loss. Finally, we look at the boring stuff at the end, which actually determines how much a lawyer will cost you later. If you live in New York but the contract says Governing Law, California, you might have to fly across the country to defend yourself in court. This can make a legal battle so expensive that you're forced to give up before you even start. Always try to set the venues to your local county or state. It keeps the home field advantage and significantly lowers your potential legal costs. Does the contract require binding arbitrations or allow you to go to small claims court? Arbitration can be much more expensive than people realize, often costing thousands just in filing fees. Small claims court is usually faster and cheaper for disputes under $5,000 or $10,000. Look for a clause that allows mediation first, which is a friendlier way to settle things before hiring expensive lawyers. This is also called the entire agreements clause, and is the most potentially concerning one for trusting people. It basically says that any promises made over email, phone, or in person don't count unless they're in this specific document. If a salesperson promised you a free month but it isn't in the contract, the merger clause means you aren't getting it. Always ensure every verbal promise is written into the final version. In the US, you usually pay your own lawyer even if you win, unless the contract says otherwise. An attorney's fees clause ensures that the loser of a lawsuit pays the winner's legal bills. This is a powerful tool to prevent people from breaching a contract just because they think you can't afford to sue them. However, it works both ways, so only include it if you're confident in your ability to follow the rules. That's the practical version of what matters most. The big idea is to understand the problem, compare the right details, and avoid rushing into an expensive decision without context. If this helped, like and subscribe for more practical guides that help you compare costs, understand quotes, and choose the right pro with more confidence. For more help with your specific situation, visit Lawful Finder. Remember, this is educational only. Always consult a qualified attorney for legal matters. Thanks for watching. Remember, this is educational only and not legal advice. Always consult a qualified attorney before making legal decisions. Subscribe for more plain English legal explainers.